Fusion Mobile, quality e-learning experience on the go.
Hello and you're welcome to Fusion Mobile e-learning platform. My name is Jacob Uchenna and I'm your lecturer for economics. Today in economics we'll be looking at the study session under business organizations. The idea, a business actually, many a time, people do not actually understand that a business is not just, does not always have to do with buying and selling or just has to do with production. Business could be anything, that could be any activity that has to do with use of resources in order to generate income. That means you use resources, produce output, then generate income, and all these things, the things will continue. So in other words, when we look at a business in itself, an organization, a business organization could be a firm. A firm, in this case, that means for us to really understand what a business unit is, a business unit is a firm. And what is a firm? A firm is actually defined as a unit of production that utilizes outputs or performs economic activities in order to generate income or to satisfy human wants, as the case may be. Now, firms, when a group of firms combine to make up industry. So an industry is a group of firms that are involved in similar activities or that produce similar outputs. Now, having a good understanding of that, that means that if I have an organization such as, say, let's say, okay, let's look at, Access Bank. Access Bank, we'll look at Fidelity, EcoBank, UBA, now and so on, all other banks. When each of these banks is a firm, but a combination of all these banks will make up the banking industry. Now, having looked at this, then we now have a good understanding that a firm is different from an industry. So, looking at that, now we could classify firms based on their method of ownership. Now, firms could be private enterprises or public enterprises. When you are talking about private enterprises, you are looking at the kind of business units which are formed, established, and funded or managed by private individuals. And the major goal of private enterprises is profit. The major goal of production in private enterprises is profit making. So every activity, whether it is going to be on a large scale or small scale, will be aimed at, directed towards making profit. Now, the other one, we could also classify business organizations based on the nature of the scale of production. We have large scale enterprises and small scale firms or businesses. Now, as we defined some other time, that large scale production talks about production that involves a large amount of input. So we define scale of production according to the quantity or size of input. So here we talk about firms that have large operating basis or large premises, large operating basis as large scale firms, while the other ones are small scale enterprises. Now, looking at this, the other one, the general structure based on structure, which is the main focus of this study, we look at, excuse me, The third classification of business enterprises is talking about structure, based on the structure of the organization. So in other words, based on structure, business units or business organizations have been classified into sole proprietorship, partnership, joint stock company, cooperative societies, and public corporations. Now, the first one, we'll take the first one, sole proprietorship. The sole proprietorship is in some other cases called what? Sole trade. But the sole proprietorship is a business unit or business organization which is established, formed, and managed by just a single individual, just one person. So, in other words, it means that everything that pertains to the business has to deal with what? One person. Now, the sole proprietorship has certain features. For instance, number one, the first feature, based on ownership, is that what? It is owned by one person as an individual. Two, decisions. Okay, it is managed by a single person. Three, it is financed by personal efforts. It could be savings, or it could be just, it could be savings, it could be loans, it could be just anything that is obtained personally. Then we talk about the sole proprietorship as a business entity is not separate from the owners. So which means structure-wise, a sole proprietorship is the same as the owner. So the ownership is not different from management. Another thing is that it does not really require any special form of it doesn't require any special form of any special procedure before it is established, unlike some business organizations. Now, you see, all the risks are taken by him, and so on and so forth. Now, these are features of a sole proprietorship. Now we look at, as a sole proprietorship, what are the things, what are the various sources? Of course, we've talked about the little sources of finance that are available to the sole proprietorship, which are like, for instance, personal savings, plowed back profits. I mean, when we say plowed back profit, it means something, a business he was running, and he decides to do what? To plow back, or that means to take a profit he makes from something else and puts it back and uses it to start up, and so on. Then we could talk about what? Contributions from relatives or just personal loans obtained from cooperatives or thrift societies, and so on and so forth. So those are the things that could make up what sources of finance to the sole trader. Now, the sole proprietorship business or sole trade has its advantages as well as disadvantages. The advantages of sole proprietorship is number one, that for advantages is that number one, he reaps all profits. Two, quick decisions are made. Three, able to maintain a personal relationship with the customers 4, flexible and easy to manage. Okay, and we could also say that he actually all decisions, he is able to maintain a uniform pattern of running the business. So which means that there is no problem in terms of communication. There won't be problems in terms of dissemination, because definitely all communications emanate, or all decisions and policies emanate from one source. So now, but he also has some problems. For instance, number one is that is the disadvantages. Now, some of the disadvantages it could have is that first is that he will bear all the losses. All losses are borne by the sole proprietor himself. That's number one. Number two is that he does not enjoy limited liability. So because the business is not a legal entity, in the event of bankruptcy of the business, or where the business winds down and the assets of the organization is not enough to settle its creditors, then what happens is that even the proprietor himself ends up losing personal belongings, because the business is not separate from the owners. Also is that all losses, he loses everything, he bears all losses alone. And now there's a limited expansion, because definitely the capital that is used to establish that is very limited or small. So in other words, there is limited expansion. It usually operates at a small scale. And the other one is that because of limited managerial capacity, then there's a limited basis of operation. Expansion could also be limited, definitely, because of the extent to which the sole proprietor can actually see. So these are advantages, disadvantages, and features of sole proprietorship as a business unit. Now that leaves us with the second one. The second one we have there is the partnership. A partnership business. Partnership business. Now, just like the other one, unlike the other one, we said that is a business owned and managed just by one person. A partnership is a business that is established, owned, financed, and managed by two or more persons. A partnership is formed when some individuals just come together, they put their resources and they decide to start something. So to start a business from which they agree on certain terms, so which serves as the basis for which the profits will be shared, losses or responsibilities will be distributed. Now, for a partnership business only is established and managed by from 2 to 20 persons for general businesses, but from 2 to 10 persons when this is when it has to do with banking activities. For banking activities, the number of partners cannot be more than 10, but for other forms of businesses from 2 to 20, minimum of 2, maximum of 20. Now, the thing now, as I mentioned earlier, that the partnership business will only happen when people come together on certain basis of agreements. Now, the document, this thing that actually states the basis of the agreement between these partners in a partnership business, we refer to it as a partnership deed. A partnership deed. So, which means that a partnership deed is a legal document which actually states the terms and conditions of the agreement between the partners in a partnership business. Now, the items that you could find in a partnership deed include the names of the partners, the name of the business, the nature of the business, address of the business, the amount contributed by each partner, the structure of the partnership, that means the role of each person in the partnership, the method of sharing profits, interest on capital. You could also talk about interest on drawings. When drawings are made, then the proportion to which the profits will be shared when made. Now, also, when a partner contributes extra capital, what will be the interest on the extra capital or loan that is given by the partners? Now, these are the information that we could get in a partnership deed. Now, we'll look at the next thing. Next up here, we'll look at what? Types of partnerships. We have, under this, we have the ordinary partnership, and we have the what? The limited partnership. The ordinary partnership and limited partnership. Now, the ordinary partnership is just a case where the type of partnership which is just in which all the partners involved none of them enjoys limited liability. It means that everybody enjoys unlimited liability, meaning that, like I said before, that if in the event of winding up of the business, that the assets of the organization is not able to settle the creditors, the partners lose personal assets. Since a partnership as well is not a legal entity. Now, the types of partners now. Okay, the limited partnership is that some or all of at least one of the partners enjoy limited liability, meaning that he only loses whatever his loss is to the tune of whatever investment he makes in the organization. Now, from there, we look at the next one, types of partners. Types of partners. For types of partners, we have the dormant, or what we call the sleeping partner. We have the other one we call the nominal partner. We also have the nominal partner. We also have the active partner. Now, for the dormant partner, or what we call the sleeping partner, he's someone that contributes to the establishment of an organization but does not participate in the active running or the day-to-day activities of the organization. So meaning that someone could contribute some money, but he lies on the sidelines while some other people run the organization, its day-to-day activities. The second one, which is a nominal partner, is a person who does not neither contributes money nor participates in the running of a business, but only contributes his name into the business. For instance, certain pharmaceutical organizations employ or have to engage a pharmacist, a registered pharmacist, a licensed pharmacist, as a partner for the business to fly. So, but in the absence of that, there could be challenges, legal challenges with that. So, in other words, such cases are examples where we could have nominal partners. Then the next one, we have the active partner. It's a kind of partner that actually contributes to the to the establishment of the organization and takes part in the active day-to-day running of the organization, of the business. That is the 3 types of partners and 2 types of partnerships. Now, partnership as a business organization has certain features as well. First feature or characteristics of partnership, number 1 is that a partnership is established by 2 or more persons, 2 to 20 people for general businesses, 2 to 10 persons for banking agreements or banking businesses. Number 2 is that a partnership ordinarily is not a legal entity. It means it is not separate from its owners. Ownership is the same thing as the management. Now, the third thing is that the capital is raised by the contribution of the partners mainly. So it means that each partner being involved in the partnership will contribute their own quotas and eventually start the partnership. Then fourth is that in a partnership, the rules for running the partnership is contained in the partnership deed, which is the partnership agreement. Now, these are some of the advantages of partnership. Then of some features of partnership agreement. Now we look at what advantages. We'll be looking at that one as well. And number 1 is that the partnership agreement involves 2 or more persons, so which means that there is better management. That's number 1. So a partnership agreement enjoys better management. And number 2, since better management are involved, that means there will be what? There will be better policies, since many heads are coming together to make and refine or debate over policies before they come out. And 3 is that the partnership is more like, okay, of course the profit motive is what makes the establishment of a partnership, so which means that the profits are actually distributed among this thing. Then number 4 is that that expansion is higher than expansion and operations are much more efficient than in the sole proprietorship. And another thing, so now we go over to disadvantages. The disadvantages of a partnership, we could point them to number 1, because of course in the advantages we mentioned that a lot of people, that decisions have to be debated on before they come out. Of course, that could lead to a disadvantage, which makes there to be slow decision making, of course. Then number 2 is that definitely one person does not make the decision, so that means once a policy is reached, it cannot be changed on site, so which means it is it is rigid. Okay, management and policies are rigid and cannot be refuted. Then the third one is that the death of a partner could mean the end of the business. Of course, the death or resignation of a partner means could mean the end of the business. It depends on which partner. Then another thing is that the partnership business becomes less personal, in the sense that it does not really pay attention to the individual needs of the consumers or the customers, as the case may be. Now, talking about that, now looking at a partnership, we just mentioned that a partnership could be dissolved or could be wind down. Of course, when it winds down, since it is not a legal entity, the partners lose more than what they invested, not just what they invested, so they don't enjoy limited liability. But now, we now look at something else. The next thing we'll be touching is the methods or procedure, reasons for dissolution. Reasons for dissolution of a partnership. Okay, reasons for dissolution of partnership. Number one reason is death of the partner. When a partner dies, definitely the organization ends, the partnership ends. That is one case. Then another case where there is admission of a new partner. When a new partner is admitted, then the whole structure of the old partnership has to be brought to an end, and another new agreement has to be set up. Then 3 is the expiration of time. When a partnership has been set to expire at a particular time, once that time gets to the time, the business ceases to exist, except when there is ratification. Then another one is by express order of the court. When there is an issue and the court is the court orders for the dissolution of the partnership, then there is no choice but to dissolve. And of course, when there is discharge of activity, that means that if a partnership was set up for a particular purpose, once it has discharged or achieved the purpose, then it is dissolved. Now, these are examples or certain reasons for which a partnership can be dissolved. Now, we move to the phase 2 of the business organization. Here, we now talk about the joint stock company, which is the third here, the joint stock company. Now, the question, a company. Now, all we've been discussing, there are no cases where we've always mentioned not a legal entity or not being a legal entity for the sole proprietorship and partnership. But now, a company is a firm that is formed or established by different individuals who come together and pool their resources to establish an organization which is separate from its owners. That means that the organization, the company, the major difference between a company and the other forms of business is that it is separate from its owners. Ownership is different from management, so it is a separate person, what we call an artificial human being, an artificial entity. So now, in such case, a company, like we just defined, is an organization or a business unit formed by a group of individuals coming together to with their resources to establish a business that is separate from its owners. So in other words, one of the features of a company is that ownership is different from the management. 2 is that it is established by 2 or more persons. 3 is that it is established legally under certain provisions of the law, especially under the Corporate and Allied Matters Act. Then 4 is that companies are expected to render accounts to either the shareholders or to the public, as the case may be. And 5, the owners, of course, are called shareholders. That means that they are entitled to certain shares of the profit at every point, at the end of every accounting or business season. Now, these and more could be features, general features of a company. Now, because the company is separate from its owners, the owners of a company or the shareholders enjoy what we call limited liability company. Limited liability. This is why companies or joint stock companies are referred to as limited liability companies. So the joint stock companies are referred to as limited liability companies because in the event of a winding up or bankruptcy of the organization, where the organization, the shareholders only lose the value of investment, not of their investment, not personal property. So the liability is limited to their investment in the company. So joint stock companies are referred to as limited liability companies. Now, joint stock companies or limited liability could now be classified into two. Joint stock companies can be classified into, you have private joint stock company, and we have the public joint stock company. Now, here, of course, once it's joint stock, it just means they are what? They are limited liability. So, for the private joint stock company, the private joint stock company is a company which is allowed to start business after it obtains its certificate of incorporation, which means that it does not actually need any other thing, and it is not allowed to sell shares to the general public. So in other words, a private limited liability has certain features on its own. Number one, for private joint stock company, the features of private joint stock company. Number one, established by 2 to 50 persons. 2, cannot sell shares. 'To the public. 3, well, 2, cannot sell shares to the public in the stock market. Number 3, is not required. Is not required to publish annual accounts. 4, starts full operation after obtaining certificate of incorporation. Okay, now these are peculiar features of the private joint stock company. Now the private joint stock company does not really need, they cannot sell shares to the public because it is not a public limited company. Then it can only be owned by a minimum of 2 to a maximum of 50 persons. Start full operation after this and that one, and is not required by law to publish annual account. But now, as a summary of that, now the public joint stock company or public limited liability company the public joint stock company, number one, the features. 1, established by a minimum of 7 people, of 7 to no maximum. 7 people to no maximum. Then 2, sells shares to the public. 3, it is required by law to publish accounts. 4, it can only start full operation after obtaining a certificate of trading. Now, the certificate of trading is obtained after the certificate of incorporation. Now, be it a private joint stock company or a public joint stock company, certain documentations, both of them are registered as separate entities with the Corporate Affairs Commission under the Corporate and Allied Matters Act. Now, what are the procedures for establishing a new company? Procedures. For setting up a company. Now, when we recall, a company is established to be separate from its owner, so it is a legal entity and it enjoys, the shareholders enjoy limited liability. Now, for setting up a company, certain steps have to be taken. First of all, we have the employment of people we call promoters. That's the step number 1. Engagement of promoters. So we'll be looking at procedures for setting up or starting up a company. Now, for a new company to start, the first thing that must happen is to engage the promoters. Now, who are the promoters? Promoters are actually a group of individuals. It could be the people it could be the original shareholders. So the promoters are those people that actually they carry out the initial feasibility study and bear all the pre-incorporation or pre-establishment costs of the company. Now, when these promoters are employed, what they do, the initial feasibility study, which is like a study of whether the business the company is to carry out, how well it will fare, the level of manpower that is required, the size of the market, the areas, and so many things that are involved in the whole aspects of the business. That is what they do, and every other expenditure that will be incurred. For instance, if a consultant is hired to actually carry out certain things, then it is these promoters that actually carry out the pre-establishment expenses. Now, the next one, after the engagement of the promoters, then we talk about drafting of documents. Now, the documents that are required, we have the Article of Association, association and memorandum of association. Article of association and memorandum of association. Now, these documents are actually very essential. The first one actually is a document that indicates or shows the relationship between the shareholders of the organization. That means the internal relationship of the organization with its shareholders. That is the article of association. Things that could be included are dates for general meeting, annual general meeting, the names of the shareholders, procedure for admitting a new shareholder, the nature of the business, the name of the business, the office of the business, and so on. The voting rights of each person, they are all stated in the article of association. But when we come to memorandum of association, that one is a document that shows the relationship between the company and its environment. That means it tells the relationship between the organization and the general public. So it tells us the nature of the business, the name of the organization, the nature of the business, the office, and so on and so forth. Those are also named in the memorandum of association. Now, the third step involved here is application and filing in. Now, after preparing these documents, a formal application for incorporation is forwarded to the registrar of companies with a formal application for incorporation. Now, the documents are filed with the application and sent to the chamber of the Corporate Affairs Commission to the registrar of companies. Now, this registrar now takes time to assess these things and check whether it is worth or not. Now, the next thing is issuing certificates of incorporation. Issuing certificate of incorporation. Now, when the registrar of company is satisfied, okay, after filing and assessment is made, the next thing, after satisfactory assessment of the documentation, the next thing is to issue a certificate of incorporation. Now, a certificate of incorporation is a document which legally establishes a business as an official entity separate from its owners. What that means is that the business can sue or be sued. The liability of the shareholders are just limited to whatever they have invested in the organization. The organization, that makes the ownership of the organization separate from its management, and through the certificate of incorporation. Now, after an organization has obtained a certificate of incorporation, it can commence full operation if it is a private joint stock company. But if it is a public joint stock company, it files in a prospectus, preparation and filing of a prospectus. And the last one is what? Certificates of trading. Now, because a public limited organization will have to sell shares, then they prepare a prospectus and file to the registrar of companies, and a copy is sent to the stock market. Now, at obtaining a certificate of trading, the organization is empowered to now become a public joint stock company, to sell shares in the stock market. Now, these are the steps in setting up or establishing a company. Now, what are the sources of finance? Various sources of finance to a joint stock company. Sources of finance. To a joint stock company. Number one, you have shares. Shares. Okay. Selling of shares. Debentures. Selling and obtaining debentures. Loans. As corporate loans. Overdrafts. We could have trade credits. We could have retained earnings. Which is more like saying plowed back profits. Then, now, this could, now when we talk about shares is a unit of a capital. So a company can raise funds or can raise capital or finance by issuing and selling more units of its shares to the public. So then the shares could be shares. Definitely, when a person buys a share and a share is allocated, or a share of a company is allocated to an individual, the individual is now referred to as a shareholder. And as a shareholder, the shareholder is a part owner of the organization, and the organization pays him dividend to the tune of his earnings on what he has invested as his share. Now, the shareholders, shares could either be ordinary or preference shares. That is two basic classifications of shares. You have ordinary shares and preference shares. The ordinary shares here talks about the shares of the original owners, a kind of share in which the earning rate is not fixed, and the ordinary shareholder is not settled until other debts of the organization has been settled. So in the business period. So which means that the ordinary shareholder is basically called the owner's equity. Now the other one, which is the preference shareholder. The preference shares are the type of shares that receives special attention. Once the company, at the end of the business period, the preference shareholders are settled from the profits. That means the dividends are paid before any other person in the organization. So in other words, a preference shareholder earns a fixed rate of dividend on his investments. Now debentures is a form of loan, a loan certificate. A debenture holder, a debenture is a liability or a claim by an external person on an organization, and the organization uses it as a source of finance. When an organization sells a debenture, anybody that gets the debenture is giving money. Organization that gets the debenture gives a loan to the organization. Now, the debenture is issued to the organization or entity as an evidence of indebtedness of the organization to the party. Now, the debenture holder is by no means a shareholder, though, so which means he is not part owners of the organization. Then that means but his loan earns a fixed interest as agreed at the end of every given fixed period. Now, the next one, we have the loans and overdraft. We have corporate loans. Loans obtained from financial institutions at certain conditions and repayable within a certain period at a fixed rate of interest. That is loans. Overdrafts are excess which the financial institution is allows the company to draw over its account balance as debit. Then the organization pays interest only to the tune of the overdraft and not to the total value on the account. Then the trade credits are allowances which the organization could enjoy from its customers whenever it needs to finance. Okay, then the retained earnings are also referred to as plowed back profits. Now these are different sources of finance of this thing. Now there are sources of finance available to the joint stock companies. Now before we go on, you will have some questions popping up on your screen. You take a look at them and we'll come back for the second part of the study session.